Maritime collision in the Egyptian law. Collision is a maritime danger that frequently occurs, especially after the increase of the number of ships sailing in the seas, multiplication of their velocities, and unification of navigation line. Such lead to mass damage to persons and properties. International rules were set to avoid collision in the seas. Such rules were approved in the International Convention for Safety of Life at Sea, SOLAS, held on October 20, 1972 in London, and were approved in Egypt by virtue of the Presidential Decree number 357 of the year 1986. On September 23, 1910, Brussels Collision Convention unified the substantive rules related to maritime collision, which were approved by Egypt by law number 22 of the year 1941, but it didn't deal with the jurisdiction issue, though it utmost important. Thus, unification of the rules related to the criminal civil jurisdiction was decided, where even two conventions were concluded in this regard. The first is the International Convention for the Unification of Certain Rules in Relation of Criminal Jurisdiction in Collision Cases and Other Maritime Accidents, which was signed in Brussels on May 10, 1952 and approved in Egypt by the law number 133 of the year 1955. Then the Ministry of the Foreign Affairs issued a decree to publish and implement the convention as of February 24, 1956. And the second is the International Convention for Unification of Certain Rules in Relation of the Civil Jurisdiction in Maritime Collision Cases, which was signed in Brussels on May 10, 1952 and approved in Egypt by the law number 34 of the year 1955. Then the Ministry of Foreign Affairs issued a decree to publish and implement the convention as of February 24, 1956. Articles 301 in the first chapter of the fourth part of Egyptian maritime trade law stipulated all matters in relation to collision accident. The provision of such articles are identical to the provision of Brussels Convention 1910 to unify the regulation of such collision on both of the national and international level. The provision of the aforementioned convention shall apply if all ships which involved in the collision belong to different states which sign or adhere to the convention. However, if all the ships which involved in the collision are Egyptian, the Egyptian law shall apply and not the convention. Essence of maritime collision. Definition and condition of maritime collision. The first paragraph of Article 292 of the Egyptian Maritime Trade Law stipulated that in case a collision occurs between maritime ship or maritime ship and international navigational boats, compensation which are payable for the damages occurring to the ship, object and person on board of such vessel shall be settled in accordance with the provision prescribed in this chapter, regardless of the waters in which the collision has taken place, with the exception of the floating vessel which are tied to a fixed berthing place. Each floating vessel shall be considered by virtue of the provision of the present article, a maritime ship or an internal navigational boat, according to each case. According to the previous definition, three conditions shall be fulfilled in order to consider the accident as a maritime collision. First, collision occurs between two floating vessels. Second, one of the vessels at least shall be a maritime ship. Third, physical collision between the two vessels shall take place. Nevertheless, the second paragraph of Article 292 stipulated that even if no material collision has taken place, the provision prescribed in this chapter shall apply. The compensation payable for the damages to be caused by one ship to another or to the object or person on board such ship if this damage have resulted from a movement made by the ship or by neglecting to make such movement, or also by the failure to observe the provision prescribed in national legislation or the international convention in force in the Arab Republic of Egypt concerning the regulation of sailing on seas. Non-application of maritime collision provision in certain accidents. Maritime collision provision do not apply to military ships. However, Article 293 of the Egyptian Maritime Trade Law stipulates that the provision of this chapter, except for the provision of Clause 2 of Article 30 of the present law, shall apply to maritime ships and internal navigational boats to be appropriated by the state or a public person for a public service or for non-commercial purposes. Maritime collision rules shall not apply to the collision that take place between the pilot boat and the ship which use it. However, this type of collision is governed by a special provision stipulated in Article 288 of the Egyptian Maritime Trade Law, which states that the ship furnisher and outfitter shall be responsible for all damages to be caused to the pilot boat during his implementation of pilotage work, unless the damage is established to have been caused by a gross fault on the part of the pilot, and this is an exception to the collision rules. Finally, maritime collision provision shall not apply the collision that take place between the tugboat and the tugged vessel, because both ships are parties to a previous two-way contract that determine the obligation of each of them. Maritime collision rules. Maritime collision rules vary according to the reason of each collision. Maritime trade law differentiates between four types of collision: force majeure collision, collision having its causes doubtful, collision resulting from a shipmaster fault, and collision resulting from a mutual fault. Force majeure collision and that having its causes doubtful. Force majeure collision is that resulting from a force majeure as a thick fog which renders the vision impossible. Great storm, public authority order to navigate have the light switched off during war if a collision took place as a result without attributing a fault to any of the ship. While the collision having its causes doubtful is that which cause cannot be determined for certain. In this case, the collision is unknown whether it is due to a force majeure, shipmaster fault, or a mutual fault of the shipmaster.